Section 122 of the UK Insolvency Act 1986 specifically provides a distinct ground for applying to have a company wound up on the grounds that it is just and equitable to do so. So in the context of this, equitable means fair, so it is just and fair to do so. Now, which of the following parties may petition to have a company compulsorily wound up on the basis that it is just and equitable to do so? Well, there are a number of ways in which stakeholders, parties can apply to the courts for a company to be liquidated, but just and equitable is a very specific one. It applies uniquely to the shareholders of the company. It's quite a broad term, and it's there in order to protect shareholders, to give them that safety net that says, look, something really bad has happened here, something really problematic has happened, and for whatever reason, there's a determination to keep the company going, and we don't think that's right. So you'll have seen case law. Maybe there is a total breakdown in the members or directors of the company. Maybe the main object, the whole reason the organisation was set up, has failed or become impossible. So, for example, let's say that I'm a company that organises fox hunting in the United Kingdom, fox hunting with hounds. Well, if that becomes illegal, as it did in the United Kingdom, then any organisation arranging fox hunts becomes illegal. If the company does not wind itself up, then a member may apply to the courts and say, look, the whole reason this company exists is now non-existent. The other shareholders, for whatever reason, aren't following this. We ask the courts to intervene. Now, of course, creditors, other stakeholders, they do have the right to apply to the courts for a company to be wound up, but that would normally be liquidation. So, for example, the creditors of the company could apply to the courts for the company to be liquidated on the grounds that it can't pay its debts, but that would not be under the just and equitable winding up principle.